Does everybody have a handout?
Hi. Okay, so I wanted to thank Sharon for making the arrangements for inviting our guest speaker and thank her for all of her help. This is our Group Therapist Network Group. We try to meet once every 2 months to 3 months. It's a way for us to network resources that we in the community know our specialty and what we do. It's been a pleasure being part of this group. I'm the founder. I reached Weiser was a big help to me when I started the group almost about 6 years ago. Irene moved to Israel, so she's not here. She's going to see what she'll do. So if any of you have to go to Israel and want information about therapy, that's where you can reach out to her. So Sharon was kind enough to take her role and to be the management and the emails and the networking and helping me out with all the emails which I created. I'm currently doing more classes and seminars. I'm not doing one-on-one therapy. I like that a lot more. I noticed that it's a passion of mine to educate and help people become aware of their issues and send them on and have them work with other people. Thank you again everyone for being here, and we'll just go around and do the introductory. And if there's anything you guys specialize in, if you have any groups coming up, any seminars coming up, please do let us know and let us know where your office is located and if you accept insurances.
My name is Sharon Ashford. I have a full-time private practice on Virginia, Wilshire. I see adults, individual adults, couples, adolescents, and parenting childhood.
Can we have everybody's business card too?
Sure.
I'm Nancy Bakidori. I'm a marriage therapist and child development, child and adults and development specialist. My specialty is working with couples and children from birth on. My office is in Encino and Beverly Hills.
Lucy Bankler is licensed in Michigan therapist. Work with individuals, couples, families. I really like working with couples. So, my name is Bella Barber. I'm not a therapist. Dr. Amiri invited me to come to this particular meeting. I'm a divorce mediator. I moved out here from New York. My offices are located in Beverly Hills as well as the West.
My name is Marcia Teichman. I'm a family therapist. I see couples, adolescents, and families, as well as individuals, and my office is in Beverly Hills.
I'm Hadass Laureano. I am an MFT and I see individuals and families and couples, and my original specialty was adoption issues, everything connected to adoption issues, and I still have groups, and I do teen groups of adoptees, and I have birth mothers and adoptive parent groups, and that was my original specialty. Now I have a mix of all kinds of different issues. And I have also a hospital practice, which is a trauma practice, and that one is in Spanish. So thank you for letting me be here, and I'm excited to be here.
Wow.
My name is Kevin Chroman. I'm a family law attorney. My practice is exclusive to mediation and collaborative law. I also run a collaborative mediation clinic at Loyola Law School that I'll talk more about at the end of the presentation.
I'm James Walton. I'm a Ph.D. and family therapist, and I've been doing collaborative work. I started mediation training in 2000, and I've been working with collaborative practice since 2011, and I'm a specialist in working with people going through divorce and helping with the parenting plans and working with their children.
Hi everyone, I'm Sharon Reiner. Last time I was here, I was talking about my work at Jewish Family Service, where I work with domestic violence victims and their families. I also have a private practice where I see children, adolescents and adults, individuals, and I use a lot of EMDR and cognitive behavioral therapy. I see people with issues related to childhood adjustment issues, trauma, anxiety, depression, social skills issues of a wide variety. So.
I am Leora Purati, licensed manager and family therapist. I have started my practice from 2002, and I see couple, individual, and also just for all people information, I accept most of the insurances right now. So if anybody wants, they can refer to me.
I'm Robin Scheinek. I'm an LCSW. I have a private practice in Culver City that takes insurance and one on Wilshire near Highland that does not. And I see children, adolescents, individuals, couples, family therapy, and I also supervise.
Hi, I'm Abigail Chadruz, licensed manager family therapist, and I would say licensed, but I have to add that part because it took me so long to finally get it. Actually, that's why I have so much compassion for so many interns that we don't have. Usually we have more interns coming. I have my own office in Beverly Hills, and I see children and adolescents and individuals and couples, which I don't love seeing couples as much as I love seeing adolescents.
And my name is Sarah Romer. I'm an NFTI. I currently work over at Lifeline, which is an organization that helps children and families dealing with chronic and life-threatening illnesses, most commonly families that are dealing with cancer. And I'm currently looking for any other positions that people have so I can finish up my last couple of hours.
If you want to. Oh, sure. My name is Limor Fogal. I'm an NFTI. I currently work at the Florida Residential Treatment Center, so I'm working with addictions, and I specialize in art therapy, so I'm in the art therapy division.
I'm Master Pico. I am also an intern and also credentialed school counselor. I'm the therapist at Chroman High School, and I work at
We just spoke up.
Yes.
Hi.
I'm Baby Summers. I'm an NFTI. I have 6 hours left to go. I'm really excited to finish my unit this week. And I work at Jewish Family Service since 2013, and I do school counseling at Orleans. And I see a lot of children, adolescents, and individuals.
Well, thank you all, and thank you all for having us here. We're very honored to be here today. Today we wanted to present to you the different paths to divorce and how the collaborative model for divorce could be beneficial to families. And at the very end, we're going to talk a little bit about, because I received some interest in the Loyola program with respect to the collaborative mediation clinic that goes on at Loyola. So we're going to talk about that a little bit at the end. But to begin, we're going to start just talking about the different paths to divorce, beginning with litigation. So, I don't know if you all remember.
You have your recording?
Yes, we're recording. So many years ago, back in the 1950s, we had a poet laureate. His name was Robert Frost, and one of his famous poems, he ended with saying, "I took the road less traveled by, and that has made all the difference." And in divorce, nothing could be more true than making sure that you're on the right path. And the right path begins with the initial decision that you make, which process you're going to take. Litigation, as most of you know, is a process where both parties have an attorney and they go to court. So this process initially creates a situation which is a lot like what I call the game theory situation. As therapists, I imagine you guys know this better than I, but there's a very famous game theory where two people are arrested for something that went wrong, and they have two choices basically, or three choices. They could both keep quiet, and if they both keep quiet, then they get a very mild sentence, maybe a little probation, because they can't figure out who's guilty, and therefore they get a light probation. They could both point the finger at each other, in which case they'll get a couple years in jail. Or if one person points the finger at the other and the other one doesn't, the person who pointed the finger gets off, and the person who didn't is implicated and therefore gets a much higher sentence. So as you can imagine, this creates a complicated situation between two parties who, if they cooperate, they will have a very light sentence or no sentence essentially, but if they don't cooperate, they're going to be heavily penalized. That's very much like our court system. Once you get lawyers involved, and once you're going to litigation, you're inherently choosing a path where you're probably going to be implicating the other person. I've yet to see a litigation case where someone says, well, I'm lawyering up because I really think the other person's really nice. And I have no intention whatsoever of, implicating them in any kind of wrongdoing whatsoever. So, and if you read this little paragraph that I wrote, and that really is the dynamic, or that I copied, I should say, I'm sorry. And that really is the dynamic that exists in litigation. These people are faced now with a logical decision of trying to defend themselves. They want to make sure that they don't get the worst sentence. And to make sure that they don't get the worst sentence, they have to go on the offensive. And a result of following a purely logical thought process, both participants find themselves in a worse state than if they had cooperated with each other in the decision-making process. So because you've chosen litigation, inherently, you're not going to get, likely, the best result had you simply cooperated.
What you find in litigation is that families get destroyed. Their finances get used up, and frequently the children are used as pawns in the experience of trying to manipulate power over the other person. And this has lasting effects for the children over the course of their lives when they grow up. And it models for them some pretty bad behavior as far as relationships and ending relationships and what their relationships are with their parents.
Our cards?
I don't.
Your cards, yeah.
Oh, I'm sorry.
Well, what we have is.
Sorry.
Oh, that's okay. Okay.
Yes.
If you want to pass this around. We decided to put our information on the sheet.
So what happens in litigation to the family is it explodes. And the children are used. And yet the parents are going to know each other for the rest of their lives because they have children in common. So now these people, after going through horrible divorce through the court system and through litigation, they now, how do they attend birthday parties and how do they attend weddings and different family gatherings? One parent can show, the other isn't able to, and it makes the kids, as they're growing up, very uncomfortable. And it sets up for some very awkward experiences and a shattered family.
So another hallmark of litigation is a judge. And so when you're in litigation, who's making the decisions? Are you making decisions for yourself, or is a third party making decisions for you? In litigation, the judge is the one making the decisions. So essentially, a lot of the control is out of your hands. And I think that's a really important piece that people don't necessarily understand when they decide to lawyer up and when they decide to get a divorce and go through litigation. They have this sense that their experience with the court is going to be one of coffee talk. I've had so many clients who've said, well, let's just talk to the judge, let's just talk to the judge. But it doesn't work that way. You don't sit down and you don't have coffee with the judge, you don't have croissants and have a little chat, and they realize you're a wonderful person, and of course they're going to rule in your favor. In fact, it's usually quite the opposite. The litigation experience is you go to court, you have an attorney with you, your attorney is your mouthpiece. If you try to speak up, the judge will say, you have an attorney here. And so your day in court is really limited as far as where your participation is, how much you could participate, and the impression that the judge is going to get of you. And typically the impression that they're going to get of you is A, through your attorney, and B, through anything that's filed with the court.
One of the things that happens is that people have something called a personal bias, and everyone considers themselves rational, logical, intelligent human beings, and if you could just see the world from my perspective, you would understand that I'm right. And so people approach divorce when it comes to the court system like this. They feel very self-righteous. They're, obviously once the judge or my attorney or the other attorney even hears my side of the story, they're going to realize, I'm the victim and I really need to win this. And both people have this perspective. And it just never works out that way.
And even though, I mean, you do have a judge who's very familiar with the law, making the decisions are not always the same. And what does that mean? You might have heard of a friend who got divorced and they got all these goodies. Maybe they got a lot of child support, maybe they got a lot of spousal support, and you think that you're going to get the same result. I have to tell you that's just not the case. If that were the case, there wouldn't be any attorneys at all. I was just recently talking to a judge, and he was explaining that he was in a conference with other judges, and there were 2 tables of judges, each of them with 7 judges. And he gave them a fact pattern. And he said, okay, I want you to tell me how much spousal support would be awarded. And one table of 7 judges, not just one, an entire consensus of judges said 0. And the other table of judges said $10,000 a month. So that was the spread between 2 tables of a consensus of judges. So the idea that you're going to be going to court and getting, some kind of result that you imagine you're going to get is just not necessarily so.
Did they say anything about why that is? I mean, has that changed since, is that something that's changed over time, or like?
So this was last week that I spoke with this judge.
Right, but I'm saying in the past, when like women weren't working as much, for example, was there more of an, I mean, do they have anything to say about that?
Well, all I could say is when it comes to spousal support in particular, there's about 15 areas that a judge can consider. They're given broad discretion to determine how much spousal support should be and how long it should be. And the last factor is anything else that a judge wants to consider. So you're going into court and they're considering the age of the parties, the health of the parties, the needs of one party, the ability of the other party, whether there's been domestic violence, whether one person has dedicated themselves to domestic duties, the health, the education, etc. And so they take this all into account, and it's all.
Don't forget about breakfast.
Breakfast?
Because sometimes they're just in a bad mood.
So what you're saying is it's very biased.
I don't know if it's biased, but it may not be predictable.
Right.
Yeah. And so it's qualitative, this particular area, when it comes to spousal support, it's qualitative and not quantitative. So somebody comes to you and you wish that there was something that you could put into a machine and say this is exactly how much you're going to get in spousal support. And unfortunately for permanent spousal support, it just doesn't work that way. And this is where a lot of arguments come from, and judges have broad discretion, and it's hard to tell. And so these are things that clients sometimes don't understand going into litigation, just what the uncertainty is of the legal outcome, let alone the emotional and psychological outcome. Yeah. So that's a great question. And I'm kind of getting to that a little bit later, but I'll be happy to talk about it a little bit now. The children are not, how should I say, consulted in any way in the beginning of the case, and that's usually where a lot of, I think, the trauma is experienced. Later on, at about age 14, they're entitled to have their voice heard in terms of who they'd like to spend time with. And it goes into a judge's calculation. It's not necessarily determinative, but their voices could be heard around that age.
Does that mean that it would be like currently be, let's say they're younger children, do the case come back up at that point, or how does that generally go?
Yes, so I mean, if they're, let's say, 7 years old and there's a custody award, then, as they get older, if they have a preference, if someone goes back to court, that preference would be heard by the judge. So, and that leads us to our next point. Sometimes there are experts that are needed. So, in a sense, even if they're younger, they can have their voices heard. It's through an evaluation. It's called a 730 evaluation. That's based on the evidence code, and a mental health professional who is very skilled at this work and works with the court goes in and evaluates the children and evaluates the parents and what it's like to live in each respective household. They talk to the teachers, they talk to everybody, and essentially the therapist makes a recommendation as to who should have custody. Now, that's a very expensive process. It could cost $30,000 for this report. In addition to the cost of the actual report, there's litigation that goes on, and if somebody doesn't like that report, they're going to hire someone else, and it's going to be caught up in court for quite a while, and it's going to cost a lot of money, which leads us to our next step on the next page, which is simply the amount of time that a litigation case takes. I've seen cases where the parties have been married for less than 2 years drag on for 8 years. So to say that it could be 2 to 3 years could be light. That's, I'd say, a moderate or average divorce where there's certain conflict, but the real high conflict ones could drag out for years and years, and you could be going back even after there's a judgment every year to try to change spouse support, custody, child support, etc. So it's a very long and drawn out process, and I love this cartoon because it shows somebody. I know the Xerox didn't do so great, but it actually shows the attorney in a decompression chamber saying he's coming off a long, tough trial. And that's the attorney, right? So you can imagine what the stress must be like on the parents. Also, when you're in litigation, the law is applied to the facts of the case. And even though that sounds like a very obvious fact, the laws are applied to the facts of the case, we have to ask ourselves, what are the limitations of the law? So, for example, the law really doesn't like religion, right? The law doesn't like to mess around with religion. It doesn't like to make any orders regarding religion because of separation between church and state. So, particularly with religious communities, it's hard for them to get orders that are consistent with their needs sometimes, because some of those needs include some of their religious beliefs. And this is something that I think is much better addressed in a collaborative or mediation model. For example, if you're sending your child to private school and it costs, and you have a couple kids and you're lucky that it only costs $4,000 a month, and you're the spouse earning $15,000 a month is paying for it, and now this person has to pay some child support and some spouse support, and there just isn't enough money to go around. And how is that handled, and does that person still have to pay for religious school, etc.? It becomes very, very complicated. In a mediation or collaborative context, this is something that could be discussed. You could figure out a lot of creative ways to try to make both of these things happen, and I've seen a lot of creative solutions for that. For example, I just recently had a case like that, and the person decided, okay, well, when it comes to my support, we're just going to take that $4,000 and we're going to put it aside, and we're going to make like you don't even earn it, and we're going to base everything off of whatever your earnings are as if you didn't earn that money. That's something you could do in the collaborative context, in the mediation context, but the law doesn't provide for that. I think there's also a lot to be said about the issue of a get, and I think that's an entire different presentation. But again, the law has such difficulty dealing with religious issues. In New York, the get issue is dealt with by a law that says if anybody gets divorced, they also cannot impede that person's right to remarry. And in that way, they didn't specifically say anything particularly about religion, but it is aimed at religious communities that have restrictions. That gets appealed a lot in California. It's also not very straightforward how that would be handled. In a collaborative mediation context, people could sit down and talk about those issues. Also, those are issues that are often talked about prior to marriage, and there's ways to perhaps create a contract prior to marriage that could deal with the issue of the get and religious issues, so that if something does go to court, you already have a contract in place. So there are ways to kind of try to contract around and to, I don't want to say force the court's hand, but by the same token, giving them the opportunity to enforce a legal contract, that just happens to have, religious components to it. So in litigation, their hands are kind of tied when it comes to religion. And finally, I just wanted to talk a little bit about the financial costs. So once you lawyer up, like I said, the control is out of your hands. And just to give a quick example of what happens, somebody didn't bring back Johnny's jacket when they were bringing him to the other parent for their parenting time. And they get really upset. And they tell their attorney about it, and their attorney writes a letter. And now the attorney that receives that letter saying, your client didn't send back Johnny with his jacket, says, oh my God, this is going to go into a pleading. I have to respond to this. And all of a sudden there's a correspondence war, over who brought back the jacket, who should be bringing back the jacket, people looking up case law to determine who should have brought back the jacket, when and how, and really preparing for a hearing on that, and everyone writing up declarations, and this is an exhibit to the declaration. It is incredibly time-consuming because someone forgot to bring back the jacket. It sounds very funny, but a little bit.
And it's not free.
And it's not free. All of this costs money. And when you go to court, it costs money. And again, that sounds rather obvious. But I was just, again, talking to a judge, and he said, so many times I have to put things over to the afternoon. We just don't have enough time for a hearing. So you're paying for your attorney to wait. And they could get there at 8:30 in the morning, not be heard till 1:30, and they're charging you for travel time. So that's what, 4 or 5 hours plus travel time, and trust me, I don't think you can find many attorneys out there for less than $400 or $500 an hour. So you paid $3,000. Most of that time is sitting, because your time in front of a judge, I'd say you're lucky if you get 10 to 15 minutes. You're really lucky if you get 10 or 15 minutes in front of a judge. They have a lot of cases on their docket. And that's another thing that the clients don't really understand. They think you're getting your day in court, the calendar is cleared, you got 45 minutes to talk to this judge. You have about 5-10 minutes, and then there's another case. So, yeah.
That's a very expensive jacket.
That was a very expensive jacket.
Cheapest to buy
And finally, the question to ask, I think, before you go into litigation are, what are the emotional costs associated with the process? So, as Dr. Walton will tell you, divorce itself is a very traumatic event, and you really do have to consider what are the costs to the children and what are the costs to the family.
And there's research that shows that up to a year after a divorce is finalized, the emotional toll is taken just on the parents. There's an estimated 30-point drop in your IQ for the first year, and the ability to make rational decisions is significantly declines, and that's going through the litigation process. We don't have any statistics for the collaborative process with it or mediation, but I'm sure it's probably better. But it's a very traumatic experience for people, and it leaves lasting scars for everyone concerned.
And it's traumatic irrespective of which path you take and which process you take. And I think that really deserves to be appreciated. And it's just amazing to me that you're under all this stress just by virtue of the divorce, and when you choose an even more stressful path to address it. So yesterday I was at a mediation conference, and it's like someone who has, a bad cold or a flu saying, I'll see you in surgery. That's not what we do when we have health issues. We don't threaten people to, well, I'm going to see you in the emergency room, I'll see you. But we say to people, I'll see you in court. And somehow or another, that's supposed to be a tonic for all of our stress and trauma by only just creating additional stress and trauma, financial stress and emotional stress.
Because you can't settle an emotional issue through the legal system. And very frequently, the divorce is an emotional issue for people. And at first you think they can settle it, but you can't. You can settle legal issues, you can settle financial issues, but you can't settle the emotional issue. And if maybe you have a little bit of a reward from it, it lasts a little bit, and then afterwards it all comes back again. And nothing's been emotionally resolved for people.
I mean, as attorneys, we're taught to zealously advocate for the client. We're warriors. We're not as skilled as yourselves, you know, at necessarily bringing about peace. So that should be considered when you're addressing litigation. And there are times where litigation is appropriate, and we're going to get to that later. But I think it's important that clients understand some of the pitfalls for, you know, the path that they choose. Yeah.
I'm not sure if you're going to answer this, but is the mediation process as legally binding as the litigation process? How does that resolve itself?
That's a great question. Yes. So I teach mediation and collaborative law, and that's one of the first questions I ask my students who are law students. I say, you know, is the judgment you get from mediation the same as the judgment you get from litigation? And the answer is yes. So at the end of whatever process you choose, a judgment is written up. Either you help write it up, and a judge signs off on it, and it's a binding judgment, period. It's called a stipulated judgment. Or in the event that you go to court, ultimately a judge is going to essentially write up the judgment and make orders. But if you come to agreement in mediation or in collaborative law, those agreements are reduced ultimately to a judgment, which a judge signs off on. And it is 100% as binding as a judgment achieved any other way. That's a great question. Yeah.
I have a question. You'll probably get to this, but I'm very interested in this. Obviously, for mediation to work, both sides have to agree to participate in mediation. And so it's a big problem. Let's say if, you know, one side does not want, do you have anything to say about that? Or there creative ways to address this issue so that mediation can happen?
That's also a great question. It's not an easy answer. The answer that I usually have is if one person comes into my door and they say that they'd like mediation, I do ask them if their spouse is equally interested in mediation, and they're on the fence. As a mediator, first of all, you're neutral, so you're not on either person's side. And the way that I handle that particular situation is I say, would it be beneficial for me to reach out to your spouse and offer them time with me? Would it be beneficial for you to reach out to your spouse and introduce us? How would you like to make the introductions? And trying to coordinate it so that it is as comfortable as possible for their spouse to at least have some contact with the mediator and learn a little bit more about the mediation process. But you're right. You can force somebody into litigation, you can't force somebody into mediation. So they're going to have to be, you know, we try to educate them. And a lot of times it's like, I'll give a free hour consultation, you know, for both of you to come in. I'll talk about the benefits of mediation. And at that point, if you want to choose, you know, a different path, you can. But there's no, unfortunately, we can't force them into mediation.
The court sometimes forces it, but then it doesn't often yield results. I'll say you have to go meet with the mediator.
In certain civil actions, they might do court-appointed mediation. In family law, prior to having a custody hearing, you have to go to what's called the Court of Conciliation, which is basically a mediator in the courtroom or in the court house in the building, and officially meet with them. For many people, they realize that it's just kind of a checklist kind of a thing. And they go and they nod their head and they say, yeah, we're not in agreement. And the mediator just kind of, you know, writes something up and says the parties were not in agreement. The judge gets that, and then they go to their hearing. So, you know, sometimes some good work is done there, but a lot of times, especially if they have lawyers, they say, look, you know, you're not going to anything. You know, we need our day in court, and you know, we spent all this time and money preparing our declarations and everything. So, you know, usually they don't agree. If they were self-represented, maybe they will.
There's a website that you help with their therapy for a client. It's called uptoparents.org. Uptoparents.org, and it's a very powerful presentation about the damages of conflictual divorce and rejection.
Terrific.
Cool.
Yeah, thank you.
Up to parents, thank you.
So for those of you who aren't familiar with the mediation process, I just wanted to kind of run through that with you so that, you know, if you're ever speaking to your clients, that you have some information about how that process differs from litigation. So in the mediation process, the mediator is, like, as I said, is neutral. So they don't represent either side. And it is completely possible for two parties to come in and not have attorneys. In fact, it happens all the time. And for them to be walked through the process by a mediator. Typically the mediator is an attorney, doesn't always have to be, but typically they are. They help fill out all the forms, make sure that their forms are appropriate, and they start going through the process with them from the very beginning, even filing the petition. And in the petition, there's a lot of check boxes, and that's how you start a divorce. And so the check boxes themselves can be inflammatory because the check boxes say things like custody, sole, joint, other, spousal support, waive the right for the other party to receive spousal support, terminate jurisdiction for the party to receive spousal support. So right off the bat, this is so inflammatory. Somebody gets this. These aren't orders, and I don't think your typical layperson understands that. These aren't orders from the court. This is what I call, this is kind of your wish list, and there's a response that is exactly the same document that has to be filed by the person who receives the petition or is served with the petition. But nonetheless, getting served with the document and you go through it and it says sole custody, sole physical custody, sole legal custody, terminate the court's jurisdiction to award support, that's traumatic. I mean, I think that strikes fear into everybody, and unless they have somebody there to explain to them, look, these aren't orders, but nonetheless, it gives you a sense of what the position of the other party is, or it gives you a fear that the position of the other party is they don't want you to have the kids, they don't want you to have spousal support. When in fact, a lot of times, attorneys just say, look, check it off like this, because I just want to play it safe. Just in case, or to give us a good bargaining chip, etc. So we go through it together, and you say, look, this is going to be reciprocal. You want to fill it out like that, the other person's going to fill out theirs like that. But can we agree that you guys both want joint custody? Can we agree that there's going to be some spousal support? So could we fill this out in a way that makes sense to both of you right from the beginning, that doesn't create defensiveness in either one of you? So the mediator goes through all of the information with them, all of the forms with them, make sure that they understand everything, and even though they can't provide legal advice, they provide all the legal information so that they can make informed decisions. Attorneys can participate, so you can have what we call consulting attorneys in mediation, and that could, that's a slippery slope. If you have people who are collaborative and mediation oriented, it's wonderful. They're there to help you, also to provide information, and to let you know that you're not, selling yourself down the river maybe or something, that you understand whatever agreement that you're making. On the other hand, you can have an attorney who is not mediation oriented, who's your consulting attorney, and I've seen this a lot of times, and they want to show you that they're earning their keep. And so they're going to do one of two things. Either they're going to just really muddy up the waters within the mediation process, or they're going to tell you, I could do better for you in court, and just forget about this whole mediation process. And what that does is really give them the case and the money and et cetera, and what they're not telling you is, how much is that going to cost me? How much, that's the information I think every client should know. So we might be $20,000 off, we might be $50,000 off. How much is this going to cost me financially to go to court? How much is this going to cost my family emotionally to go to court? How much time is this going to take? So mediation typically takes, I'd say, within 6 months. And that's actually the shortest amount of time that you could be divorced. From the time somebody is served with their petition, I know this might be too much information for you guys, but from the time you're served with your petition, you have 6 months is the least amount of time that you can be divorced. And typically speaking, most mediations achieve that within 6 months. The other hallmarks of mediation are confidentiality and privacy. So I mean, personally, I think that rather than have all of your dirty laundry explained in black and white in a declaration, in litigation, all of the information that is shared within a mediation context is confidential. Nobody can find out that information. If it falls out of mediation, if you're in mediation and suddenly somebody says this isn't working for me, I'm gonna go get an attorney, whatever was discussed in mediation and whatever documents were generated in mediation that would not otherwise be discoverable in court, remain confidential. So if you get up there and you say, well, I came to litigation because he told me in mediation that he was only going to give me this or that, $1,000 of support, and the judge would cut you off and say, I'm sorry, don't talk about anything in mediation. Everything in mediation is covered by a confidentiality privilege. I think that's a huge benefit personally. I think that's a huge benefit for most parties. I mean, so far, I haven't found any perfect couples in my life where there isn't some dirt somewhere if they really wanted to dredge it up. And to know that you could be in a process where none of that is going to be brought up or where none of it is going to be exposed is very important, I think.
So I have a question.
Yeah.
Because I work with lawyers, are a big part of my work
Sure.
with my domestic violence clients. How does that work? Because the big issue for my clients is information. So you have a client who they're court ordered or they decide to go to mediation, they have an attorney, and now the attorney is saying, I could do better for you. And the client doesn't know, they don't know what to do and who to go to. They don't know who to consult with anymore because now the attorney, and a lot of my clients feel frustrated with their attorneys. So what's the best avenue for them to get the information they need?
So what's the scenario? I mean, just paint the scenario for me again. So they're in a mediation context, and an attorney says, I could do better for you?
Right,
or...
I mean, there's every different kinds of contexts.
Right.
There's all different, but they are working with their attorneys or they're working with a mediator and they're at some sort of a standstill where they now don't know who to turn to next. They don't trust the attorney for whatever reason. So could the person speak to the mediator at the side and say, I'm not sure what to do with this information, or where would they go to get more educated?
I would say yes. I mean, first I think you should turn to your mediator and say, I guess in this situation, if they're frustrated with their attorney, that's why I think it's so important to have kind of mediation-friendly attorneys, because that don't have a hidden agenda potentially of taking you to court. And if they want more information, so for example, maybe they want some more financial information, or they
Well,
want
I guess
more...
my question is because every time they consult with their attorney, it's going to cost them a large chunk of money just to even consult with them. Can a person speak to the mediator aside in between? Can they speak privately with a mediator, or is that only when they're together with their soon-to-be ex-spouse?
So that's a good question. Well, within mediation, there is transparency. So you're not supposed to hold the confidence of one person over the other if it is going to affect the outcome of mediation. If it's not, and they're just sharing with you a concern, then you can hold that confidence. I'm just concerned that if I share this information right now, they're going to get very upset, and it's going to blow everything out of the water. But if they told you, I have $1 million that I'm hiding in the Bahamas, how do I deal with that? You would
haven't come across that yet, but yeah.
Right. Under those circumstances, you would have to say, look, I have to withdraw unless you share that information. On the flip side, if somebody says, I'm concerned that my spouse has $1 million in the Bahamas, what could I do? I think as a mediator, you say, I think it would be important, A, to get a consulting attorney, or B, what you could also do is get other experts within the process. And I guess it depends what the issue is. I mean, if there really is $1 million in the Bahamas, then it really would be important to get a financial expert as a neutral to come in and do some forensic accounting to find out if that's in fact true. So as a mediator, those would be our options.
So one of the ways that we've handled attorneys in the past that have consulted our clients, and they've said, I'll take this to court, I can get you a better deal than what you're working on. We say, great, go back to that attorney and ask him for a signed agreement that he can do that. And also limit the amount of money that he's going to find out exactly what he's going to charge you and get him to sign that as an agreement. Okay. And as they come back from the attorney, well, he wouldn't sign any of it. So, yeah.
I'm wondering if you're dealing with domestic violence couple where one is manipulative and is behaving with power and control,
Well, that depends. It's a power imbalance that's happening in the room, and that's actually where we would go and talk about collaborative, where we would have two coaches, two mental health people working with it to create more balance. But if it's ongoing domestic violence, we have to, of course, we have to report it. But that would actually probably be a case that we would probably go to litigation if you couldn't get the balance back. If it was out of control.
Mediation is based on some element of trust.
You have to have an element of trust when you're doing collaborative remediation.
Integrity of some kind, right?
So,
And if one spouse just doesn't have that, I don't see how mediation would work.
so there's a chart at the very end of this packet, and it kind of lays out for you exactly what you're talking about, by the way. And there's an x-axis of trust and a y-axis of complexity. And you're right, if there is such a low number, low amount of trust, it probably is not a good candidate for mediation.
If you have active substance abuse going on, that's not. So if you have domestic violence, child abuse, active substance abuse going on, those are not good cases for mediation or for collaborative, because you have someone who's out of control, and there's a degree of self-control that one has to go through these other processes. Otherwise, you have to have the external that controls them.
I'm actually getting a lot of information, which is great for me, but I have the sense that this is more legal issues which would be actually out of scope of our practice. So I'm just trying to figure out what's the role that we play as a therapist. Where can we help them? Because I can't give them a legal advice, go do this, go do that. So like, as a therapist, when I'm sitting with my client, where do I go with this information?
Okay, I'd like to just jump right into working with collaborative and explain a little bit about what collaborative is. We talked about litigation, two attorneys battling in court. Mediation is the mediator working with the couple. And in collaborative, it's sort of an intermediary between the litigation and the mediator's office, where you have two attorneys, two mental health, and a financial that are involved in the process. And each individual of the couple has their attorney and their coach, which is a mental health individual working with them. And then there's a financial neutral who's in the middle. And what we do when we're working with our clients as far as doing collaborative, and there's also something called enhanced mediation, where you have a mediator and a mental health that work together. And I play the same role whether I'm doing an enhanced mediation or I'm doing collaborative. I sit down with a couple and I find their story. I ask what's the story? What have you done? What has gotten you to this position? How have you gotten here? And then I ask questions about how do you argue? What are your arguments about? And how do you fight? How do you know that the other person's angry with you? I'm trying to get some information on observing what's going on in the room. When I'm sitting there while they're doing the negotiating with the attorneys, I get a sense of, well, his left eye starts to twitch when he's really angry. So I could be sitting there and I see the left eye twitching, and I've got a sense of what's going on where nobody else might have that idea. And I can stop the process for a minute. I say, let's go outside and have a talk. Let's go for a walk here. So what's going on? Tell me about the anger. What you're not feeling heard. Usually people get very angry when they don't feel they've been heard. And so it's like, so you're not feeling heard in here. So how can we put this into words so you can feel heard in that room and your story be told? And I'll work with them on doing that, come back into the office. And because everyone who's working in collaborative understands that the mental health are present, and they're also learning about mental health through the whole process, they're open to it. And so they allow for us to be able to sit down and to talk about more touchy-feely things that you wouldn't get in litigation. They wouldn't have time for that. So in here, people have a chance to do that. One of the other things that I do with people is I ask about the divorce story, because it's really important what the children hear as to why the parents are getting divorced. And oftentimes parents don't think about this, and what that does is it gives us an opportunity to reframe for them their divorce story. Because when they're litigating, they're victims. Your father did this, your mother did that, and so everybody in their family is now a victim. of the other parent. So when I'm working with them creating the divorce story, we have to make it neutral. We have to make it, we were once in love and we wanted to have children and we had you and we loved you very much, and mom and dad, you know that we were fighting, we weren't getting along, and we tried to work out our differences, but we weren't able to, so we think that it's better for the family to live in 2 households. So what happens is you start to neutralize a lot of the high emotion and the blaming and the guilt and the anxiety. You start neutralizing it some, and they start telling that story, and for themselves they start to calm down. And what you want is, you also want to tell them, you want to tell the same story not only to your children but to your family and your friends, because you don't want your kids to hear from somebody else in school whose mother knows a mother who said, oh, we know exactly what happened here, and it gets back to the child. So we're trying to stop that from occurring so that we limit the amount of damage a kid gets.
Do they listen?
They do. It's amazing. And what's really interesting is when there are, when things start getting kind of emotional, there's another thing I want to talk about too that we use, another tool. But you can come back to the divorce story with them. Well, there was a time when you were once in love, right? Yes. Right, so you're working, this is about your child, and you're trying to get, work out the parenting plan. So, there was a time. You're still going to be a family, and this is something else I tell people at the beginning of the process. Just because you're getting divorced doesn't mean it's the end of the family. You're still a family, it's just a restructured family. And so you explain that to your children as well, that we're still a family. We're still your mother and father, we're still your parents, we're still in control, we're on the same page, because part of our work is also making sure that the parents are on the same page when it comes to the parenting plan. And when you go through collaborative or mediation, you have to be on the same page to make the agreements. When you're litigating, you're not on the same page, you're fighting it. So the parents are actually learning how to cooperate with each other, even though they don't like each other, but they're learning how to cooperate. So when they leave the process, they go forward with some skills in being able to cooperate. They were able to cooperate with their divorce, so now they can cooperate a little better with their parenting, in their parenting plan.
So practically speaking, how does your role look? Are you meeting them before they enter the legal mediation, or?
I meet them at every point. I meet them at every point that you can imagine. It depends on how they come in. They might come to me first, and then I refer them in, or they might come to the attorney first, and they give them my name, and I meet with them. The way it would work in collaborative would be, let's say the parents sign the agreement, and they meet with their attorney, and frequently then they'll meet with me. And when they meet with me, what I start working on is I start looking at their goals of what they would like to achieve. Why did they choose collaborative? What is the reason why you're choosing it? And frequently it's because we have kids, or we want to stay friends, or we have family that we're related to across the aisle, and we want to keep relations. Great, so we write all that stuff down. And how do you want to treat each other in this process? In litigation, they don't ask you that. They basically sharpen the claws. But in this, I'm asking them, is it important to you how your partner ends up at the end of this process? How important is it for you the condition she's going to be in when you're done with the divorce, or he will be in when you're done with the divorce? And they stop. Nobody's asked them that question, and they begin to think about it. So it starts opening up flexibility of thinking, which is what we want to do. We want to create a space for negotiating and flexibility, because nobody is going to get 100% of what they want. They're going to get some of what they want, and they're going to have to negotiate away some things that they might have wanted. And they have to know that at the beginning, and they're going to willingly let go of it, as opposed to having it wrenched away from them, which makes it a better. Yes.
So I have an adolescent client whose parents just separated, and I don't know exactly what's going on, but there is a lot of blame issues going on, which I have asked the parents. I mean, I have sent the message to the child, but I spoke with one of them directly, but would you suggest something like that to be done to us? before they even decide where they're going? Like to actually get them and have some, I guess a session, something similar to what you're saying.
Before they go into the divorce process?
Before.
Yeah, I mean, it's helpful for them to talk about, like something I create is called a mission statement, which is how you're going to behave with each other, like respectfully. Are you going, we're going to be respectful, we're going to put the children first, we're going to compromise, and we write this all up. And so in the middle of the process, they start fighting, and then I pull out the mission statement. I go, oh, you know what, let's stop for a minute, everybody pull out your mission statements. Oh, we're going to cooperate, okay. And we're not going to yell, well, that's there. So can we go back to the agreement that we first signed at the beginning? And then people settle down, and then they start to behave better. I say play nice in the sandbox. And so they start behaving better.
Right. And you should know one of the hallmarks of collaborative practice is that the attorneys agree not to go to court. So even though you have attorneys there who are advocating for you, they're kind of all in also. They're not there to steal the case away and run off to court and pump up fees, etc. So I was at a really interesting conference yesterday where they were talking about different ways that people deal with conflict throughout the world, and they were saying, I think it was the Aborigine tribes, when there's this big conflict, what they do is that they, gather in this central place, and there's one person, they have these terrible poison darts, I guess, and that they could kill people with. And so the first thing that they do is that they gather up all the darts, right? And they put them somewhere safe. So I'm happy to say that after maybe thousands of years, we've caught up with the Aborigines, and the attorneys agree to put away their darts, and I guess they sit around and they talk, for hours and hours, days and days until it gets resolved.
And I can tell you the mental health is important here also because you have two attorneys that have been trained to be litigators that have made the paradigm shift into being more peacekeepers and makers, and yet things can get under their skin, and on more than one occasion, I've been in a case where the two attorneys start going at it, and I have to pull them aside, and then I have to do negotiating with them, and I have to calm them down and get them settled. Because what happens with a couple is they become very positional, and our work it's interest-based, which is instead of like looking at your position, it's like, what is it that you need? What is at the minimum that you need right now? So we'll start with that. So we make sure that both people get those needs met, and then we'll just work towards the other things.
So is the entry point usually the person's attorney, the couple decides they're going to get divorced, or someone decides they want a divorce, and they go seek an attorney, but do all attorneys, is that usually the entry point into going into collaborative mediation, and then you probably would need an attorney who's got that kind of orientation, right?
Right.
So as a mental health professional, would I speak to my client and say, well, what are you looking for? Do you think, meaning, you know what I'm saying? Like, what's the feeder into this process?
It enters, the cases actually enter in three locations. They enter with the attorneys, they can enter with the mental health that are the coaches in the process, or it can enter with the neutral financials that know people that are getting divorced, and they can be introduced into collaborative through anyone who's part of the collaborative practice. And what they do is basically they take it in, and then they will present them with attorneys that are collaboratively trained and that belong to the organizations, and they talk with them, and then those attorneys give them lists of the other professionals, the mental healths and the financials that are involved in their practice groups, and that's, I guess that's how the process gets started.
Yeah, as a practitioner, there's a group called LACFLA, Los Angeles Collaborative Family Law Association, and it's www.lacfla.org, and that lists the collaborative professionals in Los Angeles County.
Thank you.
LACFLA.
Yeah, I wanted to share from my experience. I worked with a family once where the parents did have at least mediation and possibly a collaborative mediation. And it was a beautiful thing. I mean, they were so, I had worked with the family before they got divorced, and then I worked with them after they got divorced. It was beautiful. They were so peaceful with each other after the divorce. They had moved equal distance apart so that the kids, would go to school with one parent in the morning and go to the other. You barely sensed, the kids barely sensed. I mean, they weren't at the same home anymore, but it was a wonderful thing. I learned a lot from that experience. So
For children, the difference is the amount of conflict. It isn't the divorce itself. Children can be emotionally healthy after a divorce. It is the turmoil and conflict that creates the issues for the kids, and if we can reduce that. There's a book called When the Body Says No by Gabor Mate, and it's about trauma that happens through divorce and other traumas in a child's life, and it's When the Body Says No. It's a longitudinal study over about 50 to 60 years of studying kids, and it was, I can't remember the statistics on it, but it's very statistically significant on the amount of strokes, heart attacks, cancer, and weight issues that children have that come from trauma compared to control groups where trauma didn't exist. Gabor Mate.
I have a question from your experiences. What are the top 3 factors, commonalities that you've seen that couples came in to get a divorce? You know, like the top 3 that you noticed as being similar amongst couples.
Like what are the
Like
reasons?
finances, was it parenting style? Was it,
Oftentimes there's a cheating incident.
cheating?
A lot of.
That seems-
But it's hard to say because infidelity is very common in divorce, but infidelity is very common in intact families. So I can't say that it is the infidelity that actually caused it. But the vast majority of them have infidelity issues. However, the majority of intact families have infidelity issues too. They just fight. It's just there's anger with each other, and they can't get past it. And it probably has to do with their own family of origin, and it probably is the way that they handled issues in their family in the past, and attachment style differences. So they come in with their complaint, but they probably wouldn't say it's because of my family style or attachment issues. You know? So they'll say it's just, I can't stand him anymore. We fight and don't get along.
Because I remember when I was in my psyche program, I don't remember the name of the book, that the teacher was saying that a lot of times it could be that the person sees the spouse as the problem, but they keep remarrying and divorcing, and I forgot what the name of the book was.
Well, it's called in analytic, it's repetition compulsion, or
unfinished business.
Right, unfinished business. It's just people repeating styles, because what you grow up with as a kid, and you learn how to relate and what is expected of you and what's expected of relationships. People try to repeat that, and oftentimes it's unfinished business with the parent of conflict. And so I'll really simplify it, it's like they'll marry dad again, and then they'll marry dad again, and they'll do it several times.
That you want to get
And you're trying to resolve an original wound, and you're blaming the other person. You say, you're the person that's going to cure me unconsciously. You're going to cure me from this, and you don't. And
Or
so,
I'm gonna fix you.
or I'm going to fix you.
Fix the
Yeah, that's
parent.
that's another one.
I want the love from the same person that I didn't get it from.
And if I could add one more thing, money. So either too much money or not enough money.
Oh, that's a big one. Yes, money, a disparity in money.
And in-laws families, in Persia.
There's one more something that's earlier about like the story and the story. I think that's very powerful. If you come in later in the process, how imperative is that for the children and for even the parents? Retelling the story in a different way
It's very difficult. I've been brought in, sometimes I get brought in after it's just two attorneys that feel like they can handle it, and then it explodes, and then it's just gone down a really bad road, and then I'm brought in to like kind of clean it up and fix it. And that's really hard because I haven't established a therapeutic bond with either person. There's no rapport, and they're really mad at each other, and they're suspicious of me when I come in. And chances are at that point, they've already told the kids their individual stories. Oh, your dad cheated and he's leaving us. That's a big one too. Your father is divorcing the family. He's leaving us. We're going to be destitute. And it's hard when you come in at that point to recover from that. You do the best you can.
Do you have any suggestions for us? Let's say I'm working with a child right now who's very much in that kind of situation, a young child, and helping the child rewrite the story for herself so that there's not so much blame that the child is accepting anymore.
What you do is with the child, parents have to do this. As the therapist can assist the parents in doing this. But they have to tell the child that her job is to be a good student, her job is to be a child, her job is to have friends, her job is that this is mommy and daddy's world, and we're going to make sure that you're safe. And they tell the child together, hopefully, if they can do it together, or they do it separately, but have the same story. At least if they have if they could do the divorce story, how old is the child? 7. They could come back to the child, even though the child has seen a lot of trauma, they could come back, they could apologize, and they could say, look, this is what happened to mommy and daddy. We loved each other very much at one time, we got married, we wanted to have you. We both love you, and we're both your parents. And what the child's really afraid of is that there are two things. One, that they caused it. Kids often feel like they're the ones, and they're supposed to keep them together, and they're failing at their job. And so they have to let the child know that that's not their job, that we had you, and we love you, and we're going to be on the same, we're going to be your mom and dad together, and she has to see them on the same page. Somehow, they've got to put aside their selfish desires and at least work together in front of the kid and to let her know that they love her.
I think that, a 7-year-old understands because you don't get along with the kid and you work out your issues. So I think the parents can do that. So, I know that we've been fighting, but we've gone to the therapist, we've worked on working together, like getting along. And we realize that, we can't live together.
Right, and that works when you have two parents that are on that team.
Right.
And they're really fighting.
Unfortunately, that's not the situation, and the parent that is sending those messages is not going to send them. So,
They have to stop sending messages through the kid. That they just have to stop.
To the child, messages to the child, like what you were describing before, your parent is the other parent is this, or giving the child the feeling that she's responsible to hold the situation, which unfortunately sometimes parents are not on you can't have that conversation,
So as the therapist, what do you do when you have parents that are not malleable and you've got to work with the child? You do your best of letting the child know tell her what her job is about being a child and being an outlet for her to talk, but she's going to go back into that system.
Yeah.
And it's just, you can only do so much.
And also, if you can share with the other parent, I don't know if you have both parents in the room or just one, but we have to understand that this child is 50% each parent. And when you're telling the child that their parent is bad, dad is bad, or mom is bad, they're hearing that they're bad, and they're 50% bad.
Right. Right, and that sets up conflict for them.
I'm so sorry, we have 5 minutes for the end of our session.
Okay.
So we have also 2 people that came
But I
in.
wanted
Can you
to
just tell us a little bit more about your clinic?
Yes. So first of all, I wanted to say, as an attorney, there's nothing more that I appreciate than the coaches and the mental health professionals, because so much of a family law experience, of a divorce experience, is outside of my purview. You know, it's easy to say this is what the law is. It's so much harder to deal with emotions. And I love it when James is on a case and things get a little bit heated. And James, can you take care of this? and I don't know what magic you all do, but it is magical. And you talk to them and they come down and they're more reasonable, because I always say it's really not hard to get a divorce. I mean, you know, you're splitting up 50-50, you know, items. You could do that in 5 seconds if I asked you to do it right now when everybody's clear-headed. The problem is nobody is. And the coaches are so important. And I just love them being part of the process, and they're an essential component, I think, to any divorce, and they should always be part of the process. So at Loyola, we provide these services every Friday during the fall semester, so it's coming to an end soon, for free. So for modest means families. And sliding scale, and I'm not sure what the sliding scale is because I'm not in charge of that piece, but still a lot less than you would otherwise pay. Maybe, let's say, maybe it could be $200 an hour, and for that you get 2 attorneys, 2 coaches, and a neutral financial free for about 5 hours. And a mediation, and it's at Loyola Law School.
5 hours total?
5 hours total.
You say you take 6 months usually, so what happens after the 5 hours?
Well, so you could have a couple sessions. So usually you get, you know, so there's a couple services that are at Loyola Law School. It's called the Center for Conflict Resolution, and they also provide mediation services. So a lot of times the collaborative team will come in and deal with some of the more difficult issues, and then if there's some additional issues that have to be addressed, they can stay on and do mediation at the Center for Conflict Resolution.
Could they go from beginning to end at Loyola?
Yes.
Take it from beginning to end if they wanted?
Yes. And so, I mean, a lot of these cases, when it's modest means, you can address a lot of the issues in 5 to 10 hours. You know, 2 sessions, 5 to 10 hours. And when I say that, you know, something takes 6 months, a lot of times it takes a lot less than 6 months if you're mediating. Sometimes it takes, you know, 3 or 4 sessions of 2 to 3 hours apiece. So you're looking at 12 to 15 hours. So if you're given 5 hours of a collaborative session and another 5 hours maybe, or 3, 4 hours at a later time, you could generally resolve most, if not all, of the issues.
So take them from first petition to the judge's sign-off?
Yeah, so they write up an agreement at the end that they tell you to, then you have to go to the self-help center, which is in downtown, and make an appointment, and they'll kind of pretty everything up for you with respect to your agreement, but essentially, you know, everything is done from beginning to end. Some final touches have to be put on it with respect to the self-help center. Yeah.
Are these mediation interns that are doing it, or?
Oh, no. No, it's someone who just, you know, won the award for, you know, whatever, Lifetime Achievement Award for mediation, Professor Mary Colbert. And there are students involved as well, but there are attorneys who have been around for many, many years, and therapists who've been around for many years, and financial experts that you would pay, you know, also several $100s an hour for. I mean, there's probably about $3,000 of services in the room that they're getting for free.
And in my private practice, I've seen very good outcomes.
Yeah.
One family couple ended up not dissolving the marriage. Another did. And, and that's why I reached out to you.
Yeah.
Because I really have seen really good work.
And we've had, you know, really some wonderful, cases where even if they didn't necessarily resolve in the first time, literally we've had people stand up at the end of it and say, you know, I was really worried today. I was so worried that I wouldn't be heard, and I was heard, and that's what you get. I mean, you may not, you know, get your final resolution. What I always tell the students is that we're here to usher people to the point where they're ready to be. We're not here to force an agreement on them. So, you know, if they're ready to go, whatever, 1 mile, that's fine. You know, if they're ready to go the entire 10 miles, that's fine too. But we're not going to force anything on them, but we are definitely going to allow them to be heard and understood, and they could always come back to finalize something.
And more times than not, at the end of the process, I get a hug from both people as they walk out the door. You don't get that in litigation.
Out of curiosity, what percentage they decide not to divorce after?
About 12%.
about 12%.
Yeah, the statistic is about 12%.
And then what percentage of mediation cases have collaborative, a therapist and the therapist piece with the legal mediation?
So the mediation and collaborative are kind of two different processes, although they're cousins. So if you're doing a collaborative case, there's always has to be a coach involved, a mental health professional. In mediation, there are forms of mediation that we call co-mediation, or what did you refer to? Enhanced mediation, where it's kind of a tri-panel of mediators, an attorney and a mental health professional and a financial expert, and they're all mediators, but they all serve different roles. So we always like having coaches and mental health professionals in all of these processes.
Do you always have a coach?
In collaborative, I always do. In mediation, we have to ask the parties whether or not they're open to that, and especially if there's a high conflict that the mediator can't handle, then I say, look, both of you guys need to get a coach, and then you talk to them and come back to me, because this is getting too hot. I'm sorry.
So if the couple is in agreement, do you ever allow rabbinical opinion in it to come in and?
Like a religious leader.
Well, we've actually,
To allow like a religious leader to also be part of the decision
Were
making.
you asking that, or?
Yes, in fact, I mean, it was very,
worked on.
we worked on a case once where it was a prenuptial agreement, and it was kind of a shidduch situation, and the rabbi was very much involved in helping us to create the terms that were consistent with their understanding. So we do. I haven't had as much in the divorce side, but in the prenuptial side I have. But if there was something, yeah, we're always open to, if they're open to information coming in and outside parties including some information, then we are too, and we want to work with them in order to have their needs met, so that in this case, it would be religious needs are met with the legal situation, so because you want to have an enforceable agreement, or at least you want them to understand, look, this is enforceable, this isn't. We could put some language in there, but it's not going to be very enforceable. But if it makes you feel more comfortable to know that language is in there, and a lot of times that's enough for people, depending on the situation. Yeah.
Thank you so much.
Oh, thank you. Thank you.
We just have to last